All right, this is LAWS 13013, Legal Professional Conduct, Week 2, History, Structure and Regulation, and we're looking at tutorial problems 7 and 8. All right. I assume that you've been able to find the video recordings, that where I store them is under each week, so that you can find them. I've also put some PowerPoints. We got an email from a student saying that they're more of a visual learner, so I dug up all of my PowerPoints and updated them, put them up there as well, if you want to have a look at those. So you've got plenty of materials, probably too much, but anyway. The biggest week of the course is week 4. That's the one that deals with costs and liens and trust accounting. We've also got a guest speaker coming in week 4. And that's Stafford Shepherd, who's the head of the Queensland Law Society's Professional Ethics section. So he's going to come along and talk to us in the tutorial. So I suspect for that week, what I'll have to do is actually give you answer guides for the tutorial, just to allow time for him to do his presentation. I'm not quite sure what it's on, probably trust accounting or something like that, and how they do audits, but we'll see. So just forewarning you about week 4. So I'd suggest that you actually start a little bit earlier on week 4 because there's so much in it. And there's a lot of important stuff in it in particular as well. Okay, so this week we're looking at problems 7 and 8, which deal with advertising. And because the law is, I'd say, a competitive profession, advertising is an important part of the, running the business of law, if I can put it that way. So there's a lot of advertising out there. So you need to be aware of what you can and can't do in terms of advertising. All right, well, let's look at problem 7. So what it asks is, what features of the legal profession may create a negative image of the profession in the eyes of the public, and is that perception a reasonable view? So let's have a look at part 1, so that's part 1. So what features of the legal profession can create a negative image, do you think? We got any suggestions?
Amount of money people pay. The fees. Fees are always perceived as being large and create a negative perception. Particularly, I don't know if you've ever had to employ a lawyer. You probably, if you had a conveyance, you certainly would have, or if you've had to do a will, various things. So those fees can be quite expensive, depending on the complexity of the matter involved. Okay, so definitely fees. What else?
Some have the ambulance chasers, kind of inverted commas.
Yep, that's right, the ambulance chaser. I've got a good example of somebody who actually, it almost looks like an ambulance, except it's got the legal advertising on the side of it. It's got the flashing light and everything on top. And that's, believe it or not, is a permitted form of advertising. So that's the new twist, but that's not what ambulance chasing is. So what is ambulance chasing?
Basically hanging around areas where you know that there's a possibility of a liability case.
That's right.
Yeah.
Soliciting at hospitals. That's probably the best.
Yeah, it's a classic, isn't it? Or literally following the ambulance to wherever it's going. There's another one. Or tow truck drivers. That's another variation of it. Employee, giving a kickback to tow truck drivers or ambulance staff or medical professionals. All of those sorts of things fall within that. And we'll have a look at the rules around that as well. Okay, what other sorts of things?
The pace, the amount of time it takes for them to address the issue sometimes. I've got a friend who's dealing with the matter, and these lawyers are so slow that they think going to the board because it just takes too much time. And they answer, we're too busy.
It can, well, there can be lengthy processes. They're certainly going through the courts is a lengthy process.
Yeah, I think not so much the code, but if you just imagine conflict or doing mediation between two parties or initial correspondence, I think as a client you paid $5,000-10,000 in their trust account, you want some pace on it, but you are number 567 on their list, so they only look at your file once every 6 weeks or 8 weeks or whatever it is, you know.
I think that comes back to case management from a solicitor point of view as well, and knowing what you can handle from a caseload and giving your clients a reasonable time frame of expectations.
That's right. There's a mismanagement of expectations there. If you don't set them as the lawyer, your client's going to set them, and for your client, their case is the most important, so they all perceive that it should be dealt with swiftly, and which is fair enough. After all, they're paying the bills. But, you do need to set expectations that are realistic and when you're going to communicate, etc. Okay, what about the language that the law uses? I mean, you've been dealing with the language, learning the language of the law over the last, probably 2-3 years. What have you noticed about that language?
They use plain English drafting.
Depends on the lawyer.
I've been sarcastic because every lecturer tells us use plain English drafting, and when you read a case, that language is from Mars and Jupiter and Pluto, right? So I think it's all the jargons and everything else. I was just being funny there, but
yeah. Well, if you ever want to have a good look at some of the American agreements, like software agreements, you ever buy any American-based software, look at the agreements and how they're drafted, and you can see we're lucky we have a plain English movement that's been in place for a long time in Australia. If you look at some of the American agreements, they're diabolical in how they're worded. But about the language of the law, it's also a way of it's a sort of a method of control as well for the profession, because if only the lawyers actually understand what they're talking about in the judiciary, it then becomes very difficult for a layperson to actually navigate the system. So they have to employ people to actually interpret and work their way through the system. So even the language of it could be interpreted that way. And it's disempowering for lay litigants or lay people as well. All right, what about contingency fees? What's your perception about contingency fees?
Sorry, Stephen, just on that last note, I think even with when you are in court, like it's very obvious that the judiciary are talking to the solicitor only. So from a lay person, they feel almost null and void, even though you are representing them. It's a very much dialogue between the judiciary and the solicitor. So that can also come across as a very sort of isolating environment. As I said, you've got the relationship with your client, but when you're in court, it's a very nerve-wracking experience. But to have that only one-way conversation can also put that negative image for sure.
It's even how the courtrooms are designed, where the judge is elevated, and it's all about power and structure. And even not so much in civil matters, but in criminal matters, the dress as well, how they're dressed. It's interesting, isn't it? These are all historical developments over centuries, but it's all around power.
What about overcharging on your disbursements and also misappropriating client trust funds?
Well, that's certainly very negative, isn't it? Very negative, absolutely. That's right. What about the perception that it's only really wealthy people that have lawyers, and that there's a sort of mismatch in power between people who have wealth and people who don't have wealth? But these days, it's really only the really rich that can readily afford lawyers.
That's why they've brought in legal aid.
Well, that's right. But I mean, it's pretty hard to get legal aid. And there's a lot of people that fall in between the two stools of being so impoverished that you can get legal aid, as opposed to being rich enough that, paying your lawyer's bills doesn't actually have much of an impact on you. Because, it's very expensive. All right.
Sorry, Steve. I was just going to say, before this, I was probably in the only industry that's hated more than lawyers, which is real estate agents. And so
I'm glad you're improving.
So a lot of the perception that we would have of lawyers is that they just want to make things more difficult, because I think lawyers come at things from a real worst case scenario, like particularly in commercial and contract law.
Yeah.
You know, you're representing your client. You want to make sure your client is covered to the nth degree. Whereas I think, you know, real estate agents, but also people in general, often kind of are a little bit more blasé, and it's a handshake. Oh, I know he's a good bloke. I know he's not going to do anything wrong by me. And so often you would butt heads with lawyers saying, no, like, we're not going to do it like that. I'm going to make sure it's right. And other people thinking that they were just doing that to either drive up their fees or just to make life difficult.
Well, lawyers are risk managers in a way, aren't they? And they're also very conservative. I mean, you really want to be conservative and be a risk manager, because if you don't advise your client correctly and protect their interests, then, you know, you're in a situation where potentially you could be sued for being negligent. So, sorry, Inga, yes, you've got your hand raised. There you go.
Yeah, I was also thinking about the fact that I've heard people say that lawyers are dishonest and always trying to beat the system and kind of argumentative. And I was thinking it probably comes from the media that a lot of the press that lawyers get is often negative.
Well, that's right. Negative news sells newspapers more than positive news generally does. So it's good to bash the lawyers. It's always, you know, a good read. In terms of
I think it's also from that whole mentality that you can really only punch up, and often lawyers are seen as, well, you know, it is difficult, or traditionally has been difficult to get into the law. So it's often people who are more privileged that can afford to do it. So they're a pretty easy group of people to bash, because normally they're more privileged than the perception of the average society. So like, you can, you know, be mean to them a little bit more.
Well, let's go back to contingency fees for a moment. What's the American contingency fee arrangements? How do they work in the US? And is there a difference between how they work in the US and how they work in Australia?
Isn't it a percentage in the US of the damages that they?
So you can say the outcome. So basically, they can get a set percentage of what the outcome is, and it can be quite substantial. In Australia, you can have a 20% uplift on the fees for a contingency fee, but it's pegged at that. So it's much more restrictive in Australia in terms of contingency fee arrangements. But that can in itself be seen as a negative, in the sense that the lawyers are, you know, grabbing a lot more of the income or the amount that's recovered, particularly in class actions, which is another one, you know.
Yeah, I was going to say, with class actions, they take a long time, like 10 years, don't they?
They can do, yes, absolutely. What about repugnant clients? What's a repugnant client?
Donald Trump.
Potentially, although the Republicans mightn't agree. So it's somebody who generally the public holds in disdain. So, you know, a typical example, well, it might be, say, a pedophile. That would be a repugnant sort of client. So if you're representing a pedophile in a case where there's involving, you know, as it does, children, then the lawyer can be perceived as being tarnished with the same brush. Why are you, you know, arguing to protect this particular person? So that can create a negative image, and the public doesn't necessarily buy the argument, well, the law is, you know, got a blindfold on, they need representation. Solicitors don't have to represent repugnant clients, but barristers, if they fall within the terms of the cab rate rule, have to. So there's differences between the branches of the profession, as we'll see when we have a look at that. Okay, so I think we've got a fair idea of what some of the problems are for lawyers. What are some of the positives for lawyers before we actually move on to the next section dealing with some examples? What are positive stories for lawyers?
well, some voluntary work and some pro bono work that they might do.
That's right. So volunteering, it could be, for example, assisting a sporting club. It could be pro bono work. So, in fact, providing legal services free of charge. What other sorts of things do law firms do?
We are great advocates.
Very good advocates, yes.
I was going to add working for NGOs or charities.
Yes, that's right.
I was going to say, but it covers everything that they've just said, doing conscience work.
Yes, absolutely. Sponsoring community sporting and other activities. Positive advertising.
Making donations also.
Making donations, yep. All of those things that lead to a positive image in the profession. Okay, all right. Now for the fun bit. Now we understand what the sort of negative aspects are and the positive aspects are. I wanted to show you some of these ads. So what I'll do is I'll just share this screen. A lot of these are American examples, but nevertheless, they're interesting. So you can see there's one in terms of a divorce lawyer who's built their sign into a lift. So you've got the happy married couple, and as soon as the doors open, you've got a divorce ad. Then there's some more here. There's a lot of them around divorce, Buy one divorce and get the next one half price. This one here. Some of these are really bad, aren't they? Why on earth they would come up with these ads?
I like that one of the ones up there offered PayPal.
Yeah. There's a lot of divorce-related ones, isn't there? I like this one here. Just because you did it doesn't mean you're guilty. And that's actually quite true, because while you may have committed the elements of the offence, you may have also have an excuse, or maybe there's one element that's missing. So I thought that was an interesting one. Then you have the sort of Erin Brockovich sort of situations where they get a celebrity to help endorse their law firm. This is the sort of thing you'd park outside the hospital.
There's a lot of puffery and hyperbole in these
absolutely.
Sort of American crap.
It is. I know. There's some shocking things. This sort of image that somebody's tough and is going to fight for you. And you can see that there's two of them here, this Gorilla of Notion and this one here, Hammer Insurance Companies. Then this one here is sort of, it's sort of pulling at heartstrings in relation to children and family breakups. This is a really odd one. This one's almost gives you the impression of trying to guarantee a result, which is always odd. Some of these are a lot of American examples, but I've seen Australian ones. So there's a road sign outside of Guyra in New South Wales up on the Tablelands, and it's about truck stop lawyers, and it has this big picture of a truck and an accident and ring us on the side of the road. I've seen other ones that have a beer coaster. This Australian example. So it sits over the beer. When you get down to the bottom of the beer, it's all about getting how to get a divorce. Seems to be a lot of divorce ones. So there's some examples. What examples did you come across? Did you find some?
We fight for fair.
Ah, yes, there's we fight for fair. Yeah. Right, wrong is another one. There are all sorts of advertising slogans. What do you think about this whole notion of having to use a lawyer to make a claim against your superannuation for personal injuries, which seems, we never saw that if you go back a few years, you never saw ads for that. And now all of a sudden they're everywhere, all over the TV, different law firms trying to promote this notion. I mean, is it so difficult to make an insurance claim against
Hey, Stephen, do you know how much they get?
I don't, but
Okay.
it must be substantial because otherwise they wouldn't be investing so
Yeah,
much
yeah,
advertising
yeah.
in. But
I don't understand
Show the
what they're doing.
fads that we have that comes through in the legal profession. Like you'll see that come through, and then you'll see that they were deemed as an ambulance chaser when I don't think they can do it in Queensland anymore, like actually going through old PI files to see if there were claims made. There just seems to be a wave every now and again of just different ideas of what could be a money-making venture for firms.
yeah, it sort of gives the impression that you can't make a claim against the insurance provided by superannuation without a lawyer. No, I don't know. I've never been in a situation where I've had to make a claim like that. I don't know if anybody else has had any experience or knows anybody, but
People pull out their super too easily and they don't really understand what they're doing half the time and the detriment that it causes. And they probably should be getting, you know, advice from someone financial.
in more financial advice than the law.
Rather than a lawyer.
Yeah. I mean, there are circumstances, although they may be becoming more limited as time goes on, it seems, in terms of what you can take out of super. But yeah, so personal hardship and things like that is a ground to take some funds out of super to support and overcome issues like that.
I found a person had to use a lawyer because they were enacting the insurance on their super. So they had an injury and they wanted to claim the policy that they had been paying the whole time that their super was active. So a lawyer was needed at that stage because no super company wants to pay an insurance claim.
Right. Okay. So what you're saying is it's difficult that you need that legal assistance.
Yeah. So you can get your super out. That's one thing, but people take insurance policies with their super. So when your super is paid into your superannuation account, you can take out an insurance policy that dips into your super to pay for that insurance. And if you make a claim on it, well, obviously your superannuation company isn't going to be like, hey, come in, pick up the money. You've got to fight for it.
Yeah. It's interesting, isn't it?
So Stephen, mostly in the mining industry, that
yeah. So you're breaking up a little bit.
Super insurance or these claims and stuff. So the notion is normally that, okay.
Yeah, it's all right. You're breaking up. You say it was mainly in the mining industry that you see these things.
Yeah, it's more like that. Don't go with super for your insurance. Go and look after companies who just do insurance itself, because super people do not want to pay money. It's a fight.
Right. Yeah, I think a lot of I know that UniSuper, for example, has in their defined benefit schemes a superannuation component. I think even in the other parts of UniSuper they do as well. So I think it's fairly common to have that insurance. But anyway,
I think a lot, it's also, well, what I've seen is when people are already doing a personal injury claim, they then do the super claim in conjunction with that. So I've seen lawyers do like both at the same time. So like they're suing like the insurer, like their workplace or a car accident, and then they're also doing that extra claim as like a second little addendum to it.
Right. Okay. Okay. All right. Well, that's enough on that, I think. I think we've got the general picture. So what I think we'll do now is have a look at problem 8. Problem 8's good because it gets you to focus on the actual provisions that govern what you can and can't do with advertising. So we've got an example here of Murray Stacks, from the managing partner of Stacks, the law firm. It's considering all sorts of advertising strategies because he wants to build up an existing personal injuries claim, personal injuries practice rather. But he also wants to build up a new practice in migration law, but that's not an area that the firm has any expertise in at the moment. So you're being asked to advise on the ethical requirements and of the 7 strategies that he's proposing. So let's have a look at each of these strategies. So the first idea he's come up with is leaving business cards in the reception and emergency sections of the local hospital. So what do you think about that? And then
I think that he needs to have consent and then it's fine.
well, let's have a look at what the provisions are. Can you take us to any of the provisions?
Yeah, it's section 65 2A
Okay, so
of the hang on. What's
You're
it
talking
called
about the
again?
PIPA?
Yeah, Pepper. Yeah.
well, it's more 65 2B. So let's go back one step. So what we're looking at is the Personal Injuries Proceeding Act 2002, Personal Injuries Proceeding Act 2002, Queensland. And you need to have a look at section 64 and 65, because this act governs what you can do in terms of advertising for in relation to personal injuries. So section 64 says, for this part, a practitioner, whether or not the other person is acting for, okay, so it's easier for me to actually just put it up, I think, rather than try to, hang on. I'll put it up, make it a bit bigger so you can actually see it. Okay, so there's the provision. So let's have a look at what it says. For this part, a practitioner or another person, so Murray is the practitioner. Another person is somebody other than Murray. Whether or not the other person is acting for a law practice, advertises personal injury services if the practitioner or person publishes or causes to be published a statement that may reasonably be thought to be intended or likely to encourage or induce a person to make a claim for compensation. So leaving the actual business cards would fit within that definition of advertising personal injury services. If Murray got someone else to put the cards there, say Murray, for example, gave it to a nurse and said, do you mind putting that, in the emergency section of the hospital on the counter? Well, the nurse would be another person. And it doesn't matter whether or not they're acting for the law practice or not, but that person is also caught within this notion of advertising for personal injury services. Okay. Then we come down to the business card is an advertisement. Okay. Then section 65 talks about allowable publication methods. Okay, so if we look at 65.2, which was the section that was mentioned earlier, it says basically section 65 allows certain things. So you can have printed publications, you can have internet websites, can have internet directories or databases, public exhibitions of billboards and signs, provided that they're not exhibited in or on a hospital or medical centre. You can have printed documents such as flyers that you post out to people. And you can have printed documents that are a receipt or record in relation to the transaction. Okay, so they're allowable things. And then it says in 65.2, however, in each of the following is not an allowable publication. Okay. 65.2a is a public exhibition of the statement in or on a hospital. And then B is a display of the statement on any printed document gratuitously sent or delivered to a hospital or left in a hospital or on any vehicle in the vicinity of a hospital. Okay, so what's Murray actually done? To go back to what he's done, leaving business cards in the reception and emergency sections of the local hospital. So how does that fit within this? I suppose you could say it is a public exhibition of the statement because it can be seen. So I think 65.2a would be okay. And B, display of the statement on any printed document gratuitously sent or delivered. Well, it's certainly that as well. It's quite broad, isn't it? So it's sent or delivered to a hospital, left in a hospital, or on any vehicle in the vicinity of a hospital. So how far the vicinity isn't, it doesn't say within a kilometre of the hospital. It just says in the vicinity. So that would have to be interpreted, I would say, like the man on the Clapham omnibus, which is pretty old terminology, but how the public would view the notion of being in the vicinity of. Okay.
Of the 300 points, I worked it out at $43,125.
Yeah, that's right. It's quite substantial. So that amount, penalty unit fines, the penalty units are, increased for inflation every year. You can look it up and it tells you what the penalty unit figure is. So that's in relation to a business card referring to this personal injuries. But what about the migration services?
That's advertising a specialty, and he's not a special. He doesn't specialize in that.
Let's think about that, because the Queensland Law Society runs specialist accreditations. So what that is that you, if you're seeking a specialist accreditation, you've got to be someone who's practiced in that area for a fair amount of time. You then have to sit a few subjects that are taught by the Queensland Law Society, and then they examine you. And if you pass to the requisite standard, you are then certified as a specialist. Okay, so that's actually what that's referring to, specialty services. Now, this is not so much a breach of that. He's not holding himself out as well. I don't think there is a specialty for migration services. The areas you see it for are wills and estates. You see it in property law, commercial,
family, PI,
criminal. They're the categories. I think that's most of them. There's not one for migration law.
personal injury as well.
Personal injury is another one, that's right. But there isn't one for migration law. So this actually is more in terms of what's written there. You can see about advertising. 36(1), something that's false, misleading or deceptive, or likely to mislead or deceive, offensive or prohibited by law. So this is potentially more likely to be 36(1.1), 36(1.2). If you're advertising services that you can't currently offer, then that's really a false statement, isn't it? Or at least misleading or deceptive, or likely to mislead or deceive. So that's what it is. Here you can see accredited. See, this is where you're talking about accredited specialist. That's got a particular meaning. That's what the Law Society course is about, rather than the notion of a specialist. See, it's talking about a specialist accredited by the relevant professional body. Now, for migration agents, it used to be MARA, but I think so it was Migration Agents Registration Authority. Then it got, I think their name changed at some point. But I think, from memory, I think we're at the situation now that if you want to practice in migration law, I think you have to be a solicitor. I think it used to be you could just be a migration agent, but I think those rules have changed. But don't quote me on that.
That's 100% correct.
Is that correct? Yeah, I thought it was, but many years ago, I wrote a paper for MARA, setting up all of the migration agent registration subjects and how they would teach those courses. That was a long time ago. But I think that's the current position. So what you're seeing now is a lot of migration agents enrolling in law school so that they can better their qualifications to remain in that profession. But I think you're looking at these solicitor conduct rules and potentially also the Consumer Competition Act, the Commonwealth Act as well. Okay, all right. So what about the next category of things that he's done? And this is providing a 10% finder's fee to nurses and ambulance staff whose actions result in a new client for the firm. What about that one?
I've had something similar happen, Stephen, where I was approached by a tow truck driver who said I could get a cut if I gave him any business.
Right. But he's not a lawyer, is he? So he's not going to get caught by these legal provisions.
That's right. But the similar concept.
It's a similar concept, but I think it might have different results, because I don't think there's necessarily anything illegal or problematic with that. It's, but if they're a lawyer and they're asking the tow truck driver, they're going to say, we'll give you a 10% finder's fee if you find a new client. It's the same sort of position as the nurse in the actual scenario we've got. So is that permissible in terms of its effect on Murray and his law firm?
Well, probably no, but I thought it was section 71 of PIPA as well, giving or receiving consideration for for claim referrals. But there's probably something in the nurses profession as well.
Well, hang on. There's a couple of things there. Okay, so let's focus on Murray first, the law firm, rather than the nurse. So what's the problem for Murray?
Doesn't he need to disclose to the client, according to, I've got section 12.4.4, acting for a client in any dealing in which financial benefit may be payable to a third party for referring the client, provided that the solicitor has first disclosed the payment or financial benefit to the client.
Yep. So it's definitely that. You should have also 12.4.4 of the Australian Solicitors Conduct Rules. That's correct, definitely. Also have a look at 12.4.3. So this is receiving a financial benefit from a third party in relation to any dealing where the solicitor represents a client or from another service provider. There's that, but there's something else. What about in the Personal Injuries Proceedings Act? So
There's
the
a couple of
references to the
comments
rule.
in the chat there, Stephen.
Sorry, can you say that again?
There's a couple of comments there in the chat.
Oh, okay, hang on. Okay, all right. Well, tell us about section 68.
They mustn't solicit or induce a potential claimant to make a claim.
That's right. So if I put up, what I'll do, I'll share this again. I'll just have a look at this section. So there's section 68. So a person must not pay or seek payment of a fee for the soliciting or reducing of a potential claimant to make a claim. So the person must not pay. So that would be Murray. They're making the payment. That is the 10% finder's fee. Or seek payment of. So that could potentially be the nurse, I suppose, if they were trying to recover this, attempting to recover this if Murray didn't pay the 10%. That can't happen. So that's a 300 penalty unit fine. So that's clearly caught. Now, what about, let's have a look through the rest of this. The person does not commit an offence against that only by, so if you do either of A or B here, 2A or B, that's not sufficient for you to commit the offence. So A is if the person is not a law practice or a person acting for a law practice, okay, so they're totally unrelated to the law practice, advertising in the ordinary course of the conduct of a person's business as an advertiser or publisher, legal services about claims. So who's that protecting? So they're not a law practice. They're not a person acting for a law practice. So it's not Murray. It's not the nurse, because the nurse would be in effect acting for the law practice because they're acting as an agent to, they're getting paid a fee to find somebody. So somebody who's advertising in the ordinary course of the conduct of a person's business as an advertiser. So that could be, your local printing shop.
Yeah, like a
Actually
marketer
printed up
or
printed up the business card. They're not caught by this.
yeah, so someone advertising, say, in the practice in a magazine or whatever.
Yeah, that's right. So there are some protections for certain sorts of people. What about B? If the person is a law practice or a person acting for a law practice, so this is Murray or our nurse, charging a potential claimant a fee for professional services provided to the potential claimant as part of making a claim. So the charging of a fee, charging a potential claimant. So the potential claimant would be the person injured seeking to make a claim for their personal injuries. So the fact that you're charging the potential claimant doesn't mean that you've committed the offence. But paying somebody, paying the nurse, or the nurse trying to recover money would be caught by the section. So, there's a little bit of statutory interpretation involved in these sorts of provisions, but I think
sorry if I missed it, Stephen,
Yep.
but if the nurse refers him a case and he doesn't give her a fee, is that allowed?
So there's no prior arrangement between them and there's no payment. So if you look at the section, a person must not pay, well, there was no intention of ever paying, or seek payment of a fee. So the nurse couldn't seek a payment of the fee. So if they're not paying and they're not seeking payment of a fee, then they haven't breached section 68(1). But there are other provisions about, say, the nurse going around the ward saying, "Hey, do you want to make a claim?" Then giving them their brother-in-law's business card. That's caught by a different section. But this one, it wouldn't be caught, that sort of scenario. But there are
right. Thank you.
Yeah.
Even the fact that it says, it says tooting, isn't that meaning an attempt to sell? So that will probably fall within that section as well.
Well, there's 67(1)A, which deals with nurses and ambulance staff as well. So you need to have a look at section 67, which really captures those other situations. Yeah. All right.
Stephen, does the payment also include giving gifts?
Well, that can be construed as a payment. It talks about a fee. So a fee could potentially be monetary payment, or it could be some other form of payment. So it would capture gifts as well. Because you're being provided with something of value to do the service. All right, we'll keep going. All right, number 3. All right, placing a sign on a bus shelter, on the main road outside the local hospital. The sign reads, "Injured ? Get stacks for your trouble, initial free consultation, phone," and then a number. Okay, what do you think about that?
The coverage, the PIPA, 62 to 69 on that.
All right, so just run us through the provisions. What are you
looking at? Advertising personal injury services.
Okay, hang on, I'll put the sections up so you've got something to. I've highlighted a few things, but okay, so that's advertising personal injury services. Just having a look at that, does it fall within this? it's certainly advertising, it's publishing, it's sought to induce a person to make a claim for compensation or damages. So it's talking about, I mean, you could infer that from it potentially, can't you? Get stacks for your trouble. It's because Stacks is the name of the law firm, so it's got a double meaning, hasn't it? On one sense, it's the name of the law firm. We can help you, and the other sense is we can get you a lot of money for whatever your injury is, because it's pegged on this notion of whether you're injured. So you could argue both ways on that sort of thing, couldn't you? So potentially it might come within advertising personal injury services. Is it encouraging and inducing somebody to make a claim for compensation for damages for personal injuries? Well, it's pretty close to the mark, isn't it? Because it's talking about injuries.
And it's talking about getting stacks of money.
Well, on one view, yeah.
Well, if you were to use their services, if you were using their services, you would have use Stacks for your troubles, not get Stacks.
Yes, that's right. So you can argue that it's potentially trying to recover lots of money. Is it published? It's not is it a printed publication? Not really. Disseminated by exhibition. That's probably more like it, isn't it? Because it's actually on a billboard.
It's also outside the hospital. So
yeah.
what's the restriction on?
Well, no, we'll get to that.
Or?
Yeah, no, we'll get to that. But it certainly will be this: publicly exhibited in, on, over, or under any building, vehicle, or place, or in the air, in view of persons in or on any street or public place. Well, it would certainly, it's on a main road, so it definitely fall within that. Okay. Now, let's have a look at this bit. So we know that it's a publication. Is it an allowable publication? It's the next question. So let's have a look at the different ones here. It's not printed. It's not a printed publication. It's not electronic. It's not on the internet. Let me come down to D. Public exhibition of the statement in, on, or under any building, vehicle, or place, or in the air, in the view of persons, or in. Okay, so it's certainly that. So it is a falls there. Then the next bit, then it says what's not allowable. So here's the bit here. Public exhibition of the statement in or on a hospital. Well, it's not in or on the hospital, is it? He hasn't stuck the sign on the physical hospital. It's on the main road outside the hospital. So then you're looking at the next bit. B, display of the statement on any printed document gratuitously sent or delivered, blah, 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 or left in the hospital or on any vehicle in the vicinity of a hospital. Well, is it on a vehicle?
Well, the bus would go to the hospital, surely.
So what's he actually done? If we go back to what he's done, no, it's on a bus shelter.
Oh, sorry, I thought it was on the bus.
No, it's on a bus shelter. So that's not a vehicle.
No.
So it's not caught by that, is it? Because it's not a vehicle. So he might be good for this one.
But does that then go back to the, where did you have that before? Sorry, 65 2A then?
I'm going to go back to 65.
Sorry.
Yeah, no, that's okay. I'll see if I can. 65 2A.
Public
No, that's in or on a hospital. No,
it's just up the road.
No, it's not caught by that either. So I suspect that's okay.
It said outside the local hospital. So I was just wondering, is outside, and you talk about these vicinity words, just how close can you push that button, I guess?
Well, that's right. And we don't have enough facts on that. But you can see how very specific these provisions are.
I'm sure I've already seen this sort of stuff locally anyway near a hospital.
Oh, I've seen it too. If you actually in Brisbane anyway, I've seen it. Outside the Princess Alexandra Hospital, there's a lawyer across the road who's got a big sign up. So
yeah, that one's for personal injuries.
yes, yeah. So I think that's probably okay on the facts that we've got. Okay, all right. So the next ones. Murray having a 1-hour talkback spot on the local radio station advising on legal issues and commenting on the outcomes of cases in the local court.
That depends on privilege.
Is that section 28?
Well, hang on. I'll just stop sharing. Let's have a think about that for a moment.
I mean, this happens all the time on can you hear me now, Stephen?
That's you're
You
coming
can
through.
share, you just can't share personal details.
I mean, you can comment on cases. It's public knowledge. You know, courts are held in the open. Most courts are held open in public, so you can comment on things. If you're the lawyer involved in the case, you might want to be very careful about what you say. But if you're not involved in the case, it's much easier. You can make comments about it, but you do need to be careful as to not to become a situation where you can be accused of not being a fit and proper person. So, for example, if you diminish public confidence in the administration of justice, if you come along on your radio, if Murray goes along on his radio show, it says this judge is hopeless. This is, you know, this is just not. This is not the way the law should be determined, et cetera, et cetera. If you bring the profession in disrepute, so if you start arguing that the barrister or whatever is incompetent or the director of public prosecutions should be shot or something, you know, those sort of things, then you're going to potentially be caught by Rule 5 of the Australian Solicitors Conduct Rules, dishonest and disrespectful conduct. But if he's not advertising personal injury services, he's not going to be caught by that Personal Injuries Proceedings Act. So as long as he's careful about what he says, I would have thought this is fine.
The area I would expect he would probably have trouble in is if you had someone ring up and ask a question, a legal question, do they then become a client at that particular point? And that then becomes a whole different.
Yeah, whether he's then providing legal advice. But I mean, even then, if you think about it, if somebody's rung up and is asking a legal question, even if technically they become a client, they're still waiving any privilege because they're raising the issues publicly. So if I was Murray, or if you were Murray, how would you respond to that?
Give me
I
a
wouldn't
call
put myself in that situation.
Sorry, one at a time. Say that again.
Sorry, I wouldn't put myself in that situation.
Well, but potentially it could arise. You know, you're on talkback radio. Anything can happen. You got like a 5-second delay. So if it did arise, how are you going to respond?
Here's my number. Give me a call tomorrow.
Exactly. That's what you say. You say, come into my office so that we can discuss this and potentially you may become a client of the firm. That's it. You don't deal with it on air. You just try and get a client. He's using this to get clients, and here's one that's actually popped up. So he just refers them to the law firm. He doesn't deal with that on the air.
I think that the whole idea of these talk shows of these lawyers is to give them publicity anyway, you know, behind a curtain.
That's one of the main reasons they do it, is to build up public recognition of them and the law firm that goes with them. It's a way of obtaining business. I mean, other ones might just do it as a public service, but, you know, it does form a form of advertising.
Stephen, sorry, just a quick question on that. So, like, obviously it would be preferable that they say, you know, hey, like, let's touch base at a later date, come to my office, etc., etc. Let's say that the question being asked was quite open and quite vague. Would it be appropriate that the solicitor could say, look, you know, there would be multitude of remedies or options available. It could be from A through to Z. But because they're not tailoring the advice, you know, to the individual, if they just did a very generalist, yeah, there's lots of different options, but to find one that suits you, come and see me and we'll talk more independently.
They could do that, or they could invent a more general scenario and say, if this, have you seen this in the newspaper? If you ever read the newspaper where the financial advisors, you know, somebody's written in about their financial situation, often you see them writing generalist statements and then say you should seek your, you know, specific advice from XYZ, your lawyer or your financial advisor. So that's how they do it. That's another way of handling it as well. So you're not actually answering the specific question. You're not giving specific advice. You're giving a general coverage of an area.
Yeah, because it's kind of like they'd be showcasing, you know, showing off their knowledge and expertise to be like, oh yes, I know the law, and there's so many wonderful things.
The reason why that works is that they're not giving specific legal advice. They're giving legal knowledge. Yeah. It's the same thing if you front up to the registrar in the Supreme Court on the counter there. One of the the registrars, on the deputy registrars on the counter, and you ask for legal advice. You know, you might be asking, how do I fill in a form, or what form do I use? They might say, generally, you'd look at this form, and that's about as far as it goes, because then they'll say, well, I can't give you legal advice. Yeah, it's the same thing. Okay, all right. Oh, we better keep going. Okay, the next one. So the next one is sending brochures in several languages to all Australian consulates around the world, indicating Stacks the law firm's expertise in migration services. Murray figures he can brush up his skills on this area, which he knows nothing about, or hire new staff to deal with any clients that arise. Well, he can certainly hire specialist staff that have the knowledge. And then there's a link. Well, what do you think about that? At the moment, he has got no one in the law firm, including himself, who knows anything about this area.
Stephen, I think as lawyers.
Okay, one at a time.
Yeah. I was going to say, Stephen, as lawyers, we're not supposed to know everything about the law. We should be able to know where to find the things about the law. So as a lawyer, you still have the right to.
But if you don't have any idea, that's not quite the same thing. You can certainly look up things, but he's.
Isn't it captured by 36.1 about false misleading?
Yeah, it is captured by Australian Solicitors Conduct Rules 36.1 because it's false and misleading. Because they don't. He's saying that they've got expertise in migration services. Well, they don't. So it's completely.
Yeah, I missed that part of expertise. Sorry.
Yeah, it's completely false. But it is correct to say that you can learn, and but you shouldn't be saying that you're an expert in the area. Yeah.
So if he's going to hire legal staff who speak Hindi, Mandarin, that's going to be another problem, isn't it?
Well, yeah. I don't know how many staff can meet that requirement. But
maybe
if you pay well enough, you probably will get stuff. All right, we'll keep going as we're going to run out of time. Visiting legal studies classrooms at a local school, lecturing students about their rights and handing out mouse pads with the phrase, need legal help, one click and get stacks. What do you think about that? It's not saying anything about personal injuries. I don't think it's going to, give rise to problems under that Personal Injuries Proceedings Act. So I don't think it's connected to personal injuries in any way. So is that a problem?
Well, Stephen, can a university lecturer give out personal advertising in the course of their business?
What, during their classes? I think that would be probably a misconduct sort of situation of a conflict of interest.
Right, so that seems quite similar to 6. So I think we're there.
Well, he's not, he's giving guest lectures, so he's probably not employed by the school. So it's while it is a conflict of interest in a sense, Well, I'm not even sure it is a conflict. If he worked for the school, definitely, and he's providing his own law firm, yeah. But you know, people do visit local schools, and so this does happen. I just don't think it's a problem.
Seem like a talkback radio, Stephen. You know, you're coming in and saying, you know, I have a law firm, come and see me later on.
Yeah, but I mean,
would it be an issue if it was a primary school?
what? Because he does or doesn't have a blue card?
Well, I don't know. Like, you know, is age a factor?
I'm not so sure. Why would age be a factor?
How is it different to when Commonwealth Bank gives you like a Dolomite, like little money box, and then
did that for centuries.
And then in 25 years, you're getting a mortgage with them because you had a little.
Yeah, but I mean, they've stopped doing that only because the barefoot investors started a campaign against them. But that was one of their most successful advertising strategies for donkeys. I can remember getting one of those when I was a kid. That was a long time ago. So
that's what I mean. Like, you got to convert them as a client when they're that young. So, like, this guy's giving a mouse pad, and then in,
you know, it might
5
be,
years they might look at it.
No, it might be even a situation he just goes along as a community service, and he just hands out some goodies while he's there. You know, it just happens to be a mouse pad. But yeah, I'm not sure that it's that problematic, that particular one. All right. I think this is the last one. It's placing a large advertisement on the side of a van with a flashing light to attract attention. Okay. So this is basically where you buy an old ambulance and you put your sign on it, you know, Stacks the law firm. Is that problematic? It's only going to be problematic if, as a moving sign, depending on what it says, of course, but if it's advertising, general advertising for a law firm, that appears to be valid. In fact, you see that all the time.
Well, you see that on buses now.
In fact, I've got 2 of them that park their cars in my street where I live, where they've got that on them.
So, I'm guessing there would be a signage rule somewhere, though, that it wouldn't be able to be a distraction for drivers and all that sort of thing. There'd have to be some sort of guideline around that.
Well, not in the Law Society rules. Not in the
no. I was talking about
the traffic rules. There might be something like that. Yeah. But I have seen this. I've seen that exact example, and I know the particular solicitor involved got a ruling from the Queensland Law Society to say that was okay. So that's the answer to that one. It's interesting. Well, in fact, it's a cheap form of advertising, isn't it? You park your van on the side of the freeway. Can you imagine the actual advertising billboards are very expensive, but you can actually park it there for a while and move it around.
You can't anymore.
Oh.
In Queensland, you can't park it there. It'll be gone within 30 minutes.
Really? Oh, it depends on how good you're public, you know. Do you get fined? Do you get fined for doing that? Are they? Okay, that's interesting. And so that's on the side of a public road, is it?
Anything on the freeways, like the
on a freeway, okay, yeah.
They will remove you if they don't mess around.
Okay, all right. So you'd have to park on a something that wasn't a freeway, and yeah. Anyway, there you go. All right, 8:03. So we've gone over a little bit. Any questions or problems? Are we traveling okay? Any issues or anybody concerned about anything? No? If you've got any problems, don't hesitate to send me an email or post a question up on the Moodle site, because I'll have a look at that. If you started forming your groups, I know some people have started forming groups for the later assignments, so have a think about doing that. Do that early. I think that's about all from me. So unless anybody else has got any questions, we'll call it a night. So it's good to see you again, and we'll see you again next week.
Thanks, Stephen.
Thanks, Steve.
No worries.
Next week.
Stephen.
Bye.